welcome to Drug School. This is your host Adam, and as always, if you do like Drug School, please like and subscribe to my channel, as well as make a donation on Patreon for me. It's patreon.com/drugschool. Today's lesson is going to be about fraud, waste, and abuse. We're going to do a little bit of defining. We're going to show some scenarios, and I want to analyze some of the case studies of fraud, waste, and abuse and their impact. With that, we're going to talk about some of the processes and procedures that prevent fraud, waste, and abuse. We'll get into the weeds of those processes and procedures a little bit later. I will glaze over them in this presentation, as well as the penalties for committing fraud. Those are going to happen in a second video, but today we're going to do part one, and we're going to basically get into what to do if you find it, and what it looks like. So fraud, as it's defined, is an act of deceit. It is done on purpose, and it is done for something other than a legitimate medical need. It is a breach of confidence that is perpetuated for profit or to gain an unfair or dishonest advantage. And this might be something where you are purposely coding something wrong, or you're dispensing something on purpose that is not what you normally would do, and you're doing it on purpose. You're doing it with the intent that this is a criminal act. And we're going to show you what this looks like. This actually happened in Michigan, and I want to provide this example of what happened.
For a time, Dr. Farid Fata enjoyed the type of popularity to match his million-dollar lifestyle. He lived in this Tony mansion and ran several upscale clinics in eastern Michigan. When Patricia Hester started feeling ill in 2010, she says she knew exactly where to go.
He's world-renowned, and when you went in his office, he was top doc.
That first visit is a day she will never forget.
And he went over the results that he said he had, and that I had MDS, a myelodysplastic syndrome, a terminal cancer of the blood, and that if
he did say.
It is a terminal disease.
Hester's story is similar to dozens of other patients who prosecutors say Fata told they too had cancer and needed immediate treatment. People like Robert Sobere, who Fata falsely diagnosed with a rare form of blood cancer in 2010.
Your mouth drops, your heart sinks.
Imagine one moment not knowing how long you will live, then after years of chemotherapy or other toxic treatments finding out your doctor lied. You never had cancer at all.
What I wanted to do to him right now was I couldn't repeat what I wanted to do. It was unbelievable.
So you were under treatment for 3 years,
3 years.
under Dr. Fata.
Yes.
And then 3 years later you find out.
It's a lie. It's all a lie.
Relief at learning they did not have cancer turned to rage for hundreds of former patients of Dr. Fata, like Hester and Sobere, just two of more than 500 victims. Prosecutors say Fata falsely diagnosed his victims with cancer or misdiagnosed them, many given unnecessary chemotherapy or other toxic treatments, all prosecutors say in the name of greed. Fata pleaded guilty to 13 counts of healthcare fraud, 2 counts of money laundering, and what federal prosecutors call one of the worst cases of medical malpractice in U.S. history. They say Fata defrauded insurance companies out of millions of dollars by falsely diagnosing or grossly overtreating his patients.
You tortured them till they took their last breath.
Sobere, Hester, and dozens of his other former patients or relatives of those patients face Fata in federal court for his sentencing. They came here to court to read victim impact statements. It was one emotional story after another. Maggie Dorsey told the court that after chemotherapy treatment she did not need, she's now a shadow of her former self. And Marietta Crabtree read a statement from her husband, who died in 2014. His statement read, "I believe Dr. Fata knowingly and purposely treated me for the wrong cancer. I am in hospice. It is my dying wish that Dr. Fata be imprisoned for the rest of his life." For his part, Fata did not acknowledge the patients who gathered at the court. Many, like Hester and Sobere, are dealing with a number of ailments as a result of his malpractice. Sobere wanted to face the man who left him with no teeth and a questionable future after the chemotherapy and radiation he did not need. But facing him in court did not bring him peace.
I should never look at him. That got me, he just gets me so upset now. And now just seeing him today just made me sick.
And Anderson Fata did get his chance to address the court. He cried. He begged for mercy, telling the court that he was ashamed for what he did. He apologized to his patients, telling them that he had failed them. Many of those patients, as you know, wanted that maximum 175-year sentence. They got the 45 years, which is essentially a life sentence, but many, for symbolic reasons, wanted the 175.
So that is the prime example of fraud that we're going to talk about a little bit later. Waste is to use or consume with little benefit. This is either a utilization of services that results in increased cost or a misuse of resources. Generally speaking, this is not illegal, but it still costs money. There are some times where it is illegal, and we'll get into those in just a moment. And the last bit is abuse, and this is for payment of products and services with no legal entitlement to that payment. That's misrepresenting the facts to obtain payment. You saw a little bit of that in Dr. Fata's case a minute ago. So we do have some abuse of the system, but we do also have some fraud in this particular instance. There was an actual intent to deceive, but you also have a misrepresentation of the facts. So in order to get a suspecting victim, you had to get the facts misrepresented so that they would consent to treatment, so that they would be able to get those payments under a fraud style of claims. So fraud was the actual claim, the actual act of doing the billing. The abuse of the system was misrepresenting the facts in order to be able to submit those claims under fraudulent pretenses. And this is a huge problem. It costs our Medicare system $4.3 billion. And this was a 2017 number. That was the most current information I have from the Centers for Medicare and Medicaid Services. We abbreviate that CMS, and we'll talk about what CMS does in a different episode. And that is for payments for services that were never rendered or claims that were altered to achieve a higher payment. And we'll talk about what both of those look like. So examples of fraud are violating an anti-kickback statute. That means you provided payments to other providers for referring services to you. It also can be providing free services to other providers for referring their services. And this used to be a huge problem in compounding pharmacies. It wouldn't be terribly uncommon where compounding pharmacies would offer samples of their treatment by basically saying, hey doc, if you want to get this compound for yourself, we won't charge you. That is providing something of value to a providing physician for the purposes of receiving business back. The expectation is that if you give them free services, they will more likely recommend you over someone else. Billing for services that are not medically necessary, which means billing for a second flu shot in an adult where you don't really need one. I have seen examples of attempts to bill a prescription moisturizer when an over-the-counter version is exactly the same thing. I think it's called a Pataderm is the name of the medication. If you look up the ingredients, it's essentially Cetaphil, which you can buy over the counter. A Pataderm has a average wholesale price of about $4,300. Cetaphil you can get over the counter for $12. really there was no medical necessity for that claim. And luckily in this case, the provider, the payer in this particular instance, denied the claim, and thankfully it didn't get billed. Billing for samples is another example for fraud. So let's say you are running a nonprofit pharmacy and you are able to get samples from a drug manufacturer. If you charge for those samples, you have committed fraud in this particular instance. There is a provision called the Stark Law. It is unlawful to provide payments for referrals of patients receiving care under Medicaid, Medicare, or TRICARE. Insurance companies have similar style rules, so it would be just violating a contract. In the case of the insurance companies, they usually go after you in the False Claims Act of a state. They won't usually go after you federally. If you do it against Medicaid, Medicare, or TRICARE, it becomes a federal case because the federal government's money is involved. Providing in-kind services in exchange for service referrals or receiving excessive payment in exchange for speeches are examples of that. INSYS just got in trouble for doing a lot of that. INSYS was actually paying doctors to prescribe a drug called Subsys, which is fentanyl. Really potent painkillers, and they were prescribing it against the REMS agreements that they had in place with the FDA, and that was deemed unlawful. And the executives of those companies have been fined. They're going to jail. There's a variety of things that are going to happen to them. There are a few safe harbors in this anti-kickback statute. So if you are working in a pharmacy and inside a doctor's office, and that doctor's office charges a market rate for rent, let's say they charge you $5 a square foot rent for renting out the pharmacy's space, that would be deemed to be a reasonable charge for rent. Now, if they said, we will ask for 10% of your revenue, different story, because that is not part of the marketplace equivalent for rent. So if rent for a retail space goes for $5 to $7 a square foot, $5 to $7 a square foot for the pharmacy actually taking up room in the doctor's office is not considered to be unreasonable in that case. Cases of waste, using brand name drugs when generics are available. Now, this could be fraud, this could be waste. It would be fraud if you were dispensing generics and billing for brand name drugs. That would be a case of fraud. Waste of services is billing for brand name medications when they're not medically necessary. And then the other part of that is the claim coded right. Who requested the brand? Was it because the brand was the only thing available and the generics are not? One of the things that we determine when it comes to waste is this sheer and simple explanation that pharma companies can control the supply of generics, and they do. In the case of Adderall XR, almost all of the generics are made by the same company that makes brand name Adderall XR. Now, if production is altered so that only brand name Adderall XR is made and none of the generics are, you could go after that as a waste of the system. You could actually go after that as an abuse of the system too, because that actually could be technically illegally monopolizing production. A case of waste where it would actually be illegal is in the case of doctor shopping, and that is patients using multiple physicians to obtain prescriptions, and this is usually a problem in controlled substance land. Thankfully, 49 of the 50 states at the date of this publication actually have laws in place where there is a prescription drug monitoring program where we can actually monitor those prescriptions. And many of those states actually now interact with each other. I think we can now interchange data among 28 states. They all share the same system, so I can actually go in under an agreement with the state of Michigan. And if I have a patient who might be going to Ohio to obtain prescriptions, for example, I can check Ohio on a box when I'm doing the search in our monitoring system, and I can see both the prescriptions that were filled in Ohio and the prescriptions that were filled in Michigan. And it really has cut down on doctor shopping. We have done a lot of cutting down of those procedures. The reason it's considered to be waste is you're taking up that doctor's time, you're taking up those resources. And the reason it's illegal is because you are taking that time to obtain a prescription under false medical pretenses. If you try to obtain a prescription under false medical pretenses, you have committed a felony. So it's a very important distinction that has to be clarified. Abuse of the system is using an expensive, more expensive medication when a lower one is available, or billing more frequently than necessary, or in Dr. Fada's case, billing for medications that weren't needed in the first place. And this is usually mitigated by payment mechanisms, but consider a couple of examples. And I've run across these in my own practice currently, where I actually monitor prescription drug claims and try to cut down the cost of them on the employer. And one of the things that I do is I take a look at high cost claims and I try to figure out whether or not they were actually necessary in the first place. And one of the ones I came across is a drug called chlorzoxazone, used to go by the name Parafon. Usually it's available in a 500 milligram tablet, and you can get 60 of them for approximately $20. They do make a 250 milligram comparison, but take a look at the difference in the cost of these drugs. And I just really want to highlight that. Because if you take a look at the cost of these drugs, chlorzoxazone 250 milligram tablets is about $1,100 for a 60 count. Chlorzoxazone 500 milligrams is $20 for a 60 count. And the chlorzoxazone 500 milligram tablet is scored, so you can split it very easily. So there's absolutely no reason that a patient should be getting 250 milligram tablets. Or maybe phenoprofen. Phenoprofen comes in a 200 milligram and a 400 milligram. Now, I can understand the 200 milligram if you have a patient who has an intolerance to NSAIDs, because these are capsules, you cannot subdivide these. But if you have a patient who's taking phenoprofen 200 and they're prescribed the 200 milligram capsule, but they're being told to take 2 a day, then really I could have done the 400 milligram phenoprofen for a third the cost. And that would be another example of abuse of the system, and that is using drugs that are more costly to obtain payment. Billing more frequently than necessary. I came across this one in my current practice too. Automatically refilling medications without patient consent is illegal under Medicare's rules. And I came across one example of this where a patient was getting stuff from a pharmacy out in Utah. She lives in Bay City, Michigan. The distance in these is vast. So it came under my scrutiny. So why would a person in Utah and a person in Michigan be interacting with each other? And then they were auto-filling this medication. It was diclofenac, 3%. And by the way, before you nail me on a HIPAA violation, Bay City was not really where she was from, just for the record. I was using that as a hypothetical example. So do not nail me on a HIPAA violation for that, because I didn't. I actually masked where she was literally from. But suffice it to say, automatically refilling a patient's medication without their consent is sometimes called stockpiling. An example of this, patient calls me and tells me that she has a pharmacy that tells her that she's been getting diclofenac gel every month for 6 months, and she has 4 tubes she hasn't even used yet. They're all expired. Well, that cost the plan $1,400 over the course of the 6-month period. She only really needed 2 of those tubes. So billing more frequently than necessary is abuse of the system. I told her to get in touch with the Fraud, Waste, and Abuse Department at her pharmacy benefit manager. and she has done that. The pharmacy benefit manager was able to go back on the pharmacy and get 4 of those claims reversed. So what can you do about this? Follow your facility's policies and procedures. All HIPAA-covered facilities must have a fraud, waste, and abuse policy. Read it. Also, it's not effective if you do not say something. So if you see something, say something. And yes, that sounds like it came right out of a Department of Homeland Security video. If you see something, say something. And please follow the chain of command. So don't go above your boss's head unless you have a compliance officer. If you have an insurance compliance officer, especially if it involves your boss, then you need to go to the compliance officer. Whatever your facility's fraud, waste, and abuse policy says you have to do, that's exactly what you want to do. So if it's go to your manager first, especially if it's a colleague, go to your manager first, or go to that colleague first. And this is an awkward conversation to have because your colleague may not have intended to do exactly what you told them or you're finding. And I used to be the insurance compliance officer, so it was an awkward conversation when I would go through documentation and go, hey, by the way, this needs to be on the prescription if you're going to do this. But communicating those clear expectations so that you can avoid problems in the future usually will avoid instances of fraud, waste, and abuse. If the fraud, waste, and abuse violation occurs outside of the pharmacy, you're having an issue with a prescriber, go to the prescriber first if it's patient related. So if you think a patient's doctor shopping, go to the prescriber and say, hey, by the way, doc, I think this patient might be scamming you. I've done this before. I had a doctor call up and say, hey, I wanted to call in a prescription of Tylenol 3 with codeine. Pull up a MAPS, and sure enough, patient's been to 6 dentists in 3 months. And I went, hey, doc, you might not want to prescribe that. He changed the prescription to ibuprofen 800 milligrams. Patient never picked up that prescription. So clarifying medical need is important. Avoid the word why if you're going to ask probing questions. So if you're asking a doctor why brand is medically necessary, ask the doctor what is the medical need for that brand name drug. We might be able to avoid that in a generic. But notice how I worded that question. I said, what is the medical need? I'm not accusing the doctor, because if I say, why does the patient need brand? That's accusatory. I'm assuming that one of the two is trying to scam the system. If it's an overprescribing issue, especially if you are seeing prescriptions come from a long distance away and they're trying to bill it to an insurance, every insurance company has a fraud, waste, and abuse department. And if you think there might also be a legal issue with that prescription, you may be required to file a report with the Board of Pharmacy. I can tell you right now, if you are in the state of Michigan, it's an overprescribing issue, you're required to report it as a licensee of the Board of Pharmacy. So the Board of Pharmacy, by the way, has all legal authority over every violation of Article 7 of the Public Health Code, which is the Controlled Substances Act of Michigan. So if you ever see in a board disciplinary report in the state of Michigan technical violation of Article 7 of the Public Health Code, that means the Public Health Code has been violated and it's a controlled substance violation. If you're going to report this, if you have to report this, be ready to have your facts in order. Write them down. If you don't write it down, it didn't happen. Document your clinical observations. So if the patient appears drunk or intoxicated, make sure you write that information down. Positive identification. So making sure you get a driver's license number of the patient. And if you reported this instance, be ready for a visit from somebody. One of the things that happened to me was I had a patient who came in and told me that they were filling a prescription for Percocet, and I billed it to their Medicaid plan. And I happened to know the fraud, waste, and abuse department of the Medicaid plan it was getting billed to. So I called up the insurance company and said, hey, by the way, I want to take a look at this doctor and what's going on here. And they went, you have found something huge, so we are going to investigate this. And sure enough, about a week later, I got a visit from the Attorney General's office. So when that person comes in, identify who they are. So you have to identify the person who's investigating the incident. Make sure you get a picture ID of them. Again, positive identification is important. If it is a government investigation, if the state government comes in or the federal government, it doesn't matter which one, they have a right to see protected health information. You do not have to redact a document. They have a legal right to any protected health information. You lose all rights of privacy when it comes to a government investigation. So if the state attorney general comes in and I have submitted an allegation that I think something is wrong, the state of Michigan is required to come in, say hello. They are required to get copies of all of the documentation that you provided. Remember, the government has the ability to see protected health information in an investigation. It is also in your best interest to cooperate fully. Remember, you did not do anything wrong. You reported what you thought was wrong. If your employer has done illegal practices, you have a duty to report it, and if it involves a government payer, you might want to consult an attorney. And make sure you have evidence of what happened, because who reports it is important. There are provisions under False Claims Acts, especially those Stark provisions, where whoever reports it to the government may actually be entitled to a percentage of the recovery. Plus, you become protected if your employer comes back on you. But you have to make sure that you are abiding your other employment conditions, because retribution is illegal. However, if you start becoming absent from work, they can still fire you for absenteeism. So make sure you follow all of your employer's procedures. And with that, I would like to invite you to subscribe, like this video. If you have any questions, leave them in the comments. I answer all of the questions that are posed. Keep in mind, I am not an attorney, so anything that you just heard legally wise, if you think is going on in your pharmacy, make sure you consult one. But I want to thank you for watching, and I look forward to talking to you again soon. Thank you.